Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me today, my good friend and special guest, Russ Cook with Russ Cook and Associates over in Brentwood, Tennessee. Russ is a board-certified estate planning attorney, and Russ has been gracious enough to join with me today. What we're doing on our 10 callers, first 10 callers to my office, 615-376-5325. Not only are you going to get a retirement income analysis, and by that I mean a comprehensive financial plan that includes that retirement income analysis, investment analysis, tax planning. We're going to do it all for you, okay? It may take one visit, it may take 2 or 3 visits, and that's okay. There's no charge for the first 10 callers. In addition, we always get into estate planning. That's a part of putting a good plan together, is dealing with that. You know, how up to date are your wills? Do you even have wills, powers of attorney? You know, talking about the difference between wills and trusts in your situation, which might work the best. With that, Russell is going to offer up a free consultation. And normally you call his office to get this. You're going to have to, you're going to pay his hourly rate to do it. But for the first 10 callers, you can come into my office. Russ will join us. We'll do it. You'll get a joint consultation, review of your estate plan, your wills, trusts, powers of attorney, whatever you have, and talk to you about what's the strengths and weaknesses of what you have and how you can improve upon that. That's all included this week. So again, 615-376-5325. Debbie is standing by. She'll get your information, send you out a checklist of the things you'll need to bring to the appointment, as well as a free copy of my book, 7 Steps to Financial Freedom in Retirement. There we go. All right. Back to trust. Now, this is one of the things with trust that I want to get into. We talked about, again, the cost. You're going to pay a little more up front to get a trust set up and all the attending documents. So when we're talking about setting up a trust, we're not talking about just one document. We're actually talking about 5 documents. Mm-hmm. So Russ, with the trust, when someone comes in, you're going to do up a revocable living trust for them. And this is the other. There's a lot of confusion about the different kinds of trusts. So a revocable living trust versus, say, an irrevocable trust. Let's just talk about the control parts. It's still, with the revocable trust, you can change it, some of the other benefits, and then those other documents they're going to get with that.
Yeah, the way I describe revocable trusts is they're basically transparent documents while you're living, meaning that you don't have a separate tax ID number for the trust, you don't file separate tax returns, you're the trustee and beneficiary, you can revoke it at any time. A lot of times lenders won't even look, they'll look through them and see you as kind of the beneficiary and the person in control. So during your life, it doesn't really exist as a separate entity. Now, an irrevocable trust is a separate entity. That means, like a corporation or a partnership, it would have its own tax ID number, and it would have to, in most cases, file its own tax return. Right. So that's the difference. And you start with the revocable trust so that it gives you the option of changing your mind on anything that you need to change your mind on with respect to your estate plan.
So understanding, too, when we talk about revocable trust, this is a way for you to maintain control of your assets, take probate out of the equation, keep your affairs private. If you have property in other states, you avoid now multiple probates because there's not going to be a probate with a trust. It's, again, the important part is making sure that trust is kept up to date. So if you add an asset later and it's not properly titled to the trust, or the trust is beneficiary, then you could create a potential probate issue. That's why it's so important to have these. With my clients, we always cover that because I'm a part of the planning when it comes to their financial planning. If we're going to change accounts around, if we're going to make changes in their assets, we're going to make sure that the estate plan is kept in force, intact, and is kept up to date. Russ, I know, sends out letters regularly to clients as well to remind them, that they need to do these things as well. The difference is, with my clients, I'm helping them do it. That's the biggest difference. That so you'll have to gauge that for yourself. If you're a do-it-yourself type, well, guess what? You can do that too. Okay. Here's the other part with the trust, though. When it comes to these documents, this isn't something, to be clear about this, do-it-yourself. I do not recommend at all. In fact, I would say it's the worst thing you can probably do is go out and try to do your own will or trust. Is it legal to do so? Well, yeah, I suppose. But then again, I guess it's legal to perform surgery on yourself, to use probably a very bad metaphor. This is you don't want to be think of this. I'll give you an example. I had a gentleman years ago that I met with that had set up his own trust, and I was reading through the document, and I said, what was one of your goals? And he says, well, I want to make sure I avoid probate. And he had set up a trust that my brain
trust under a will.
Yeah.
Testamentary trust.
Testamentary trust, thank you.
Yeah.
So he had set up a testamentary trust. The trust, it basically was saying that it would be funded after his death, and it was going to go through probate first.
Yeah, you had to file the will in order to create the trust, as opposed to the trust being created and not needing to file the will.
So he'd gone down and just looked up all this stuff at the courthouse and thought he could do his own, and he was accomplishing the exact opposite. There was others that I've seen where people have inadvertently bypassed the spouse and had things going to the children at the first death, meaning that now the children were going to be in charge of the house and the car and all that, and the surviving spouse was going to be dependent upon the children.
Yes.
Again, not by design. In fact, the spouse, I remember at that meeting, was not happy.
No.
when I pointed out to them the way this thing was going to go.
Yeah, and I have horror stories too. I had clients that were single that used married documents, and that raised a lot of confusion when they died.
Yeah.
And I've had documents that were penned in that basically revoked them, that weren't supposed, they just changed the language using their pen, and that technically revokes a will. So you got to be careful.
There you go. I mean, getting properly drafted documents are important. And when it comes to the IRAs we had talked about earlier, this is another one of those areas. Now, I'm going to take a quick call, and then we're going to come back and talk about IRAs, and again, the importance, especially in the way those are titled, and the way an IRA, it's the same thing when it's different for spouses than when it's going to non-spousal beneficiaries. But let me go ahead and, was it Alice? Mary, welcome to the Retirement Report.
Thank you.
How can we help today?
My husband and I are in our late 70s. We sold all of our real estate about 8 years ago, and all we have is money in the bank. For beneficiaries, do we need a will or a trust?
Well, this is, so you basically, let me make sure I understand. So everything's in cash in the banks and different investments of whatever kind, and you've got joint ownership, so it's for husband and wife, right? And then when you're gone, is it going to go to your children?
Yes.
And how many children do you have?
Two.
2 children. And you may have other beneficiaries as well?
Well, my husband is the beneficiary on mine. I am the beneficiary on his, with their children being contingent on each one.
Okay. And now here's some weaknesses that'll go with that on joint, as far as now, they're not joint owners. They're just going to be a payable on death kind of thing. Is that correct?
Correct.
Okay. So some of the weaknesses there, Russ, and this goes with, I'll let you dive into this, but now it's pretty straightforward in terms of how it would work, with the exception that life tends to happen in ways. What if she becomes incapacitated or her husband becomes incapacitated? Do you all have powers of attorney?
Yes.
Do you have, and you've got a will set up?
No, she was asking if she needed
or just
one.
Powers of attorney?
Yeah.
Just powers of attorney.
Okay, just want to make sure. So we've handled one part as far as potentially avoiding conservative, and I got you and your husband as power of attorney with your children as backup?
Yes.
Okay.
Yeah, what I would say to that is, if you have the children as contingent beneficiaries, then yes, the children will then inherit the account after both you and your husband have passed. Some of the things we run into is how to handle the final expenses when the assets go directly to the children. In other words, there may be a funeral expense, there may be final debts and expenses that have to be paid, and the question is, if the children get the funds outright directly after you pass, and they're not in agreement as to how those expenses will be paid, there could be some conflict there. At least with a will, what it'll do is allow for an executor to be appointed who at least can take care of those final expenses and then distribute the remaining assets equally between the kids. So I'm not saying that it's a bad plan, I'm just saying that there might be some contingencies that you may want to make sure you take care of. The other is, if a child dies before the survivor, and unfortunately we live in a society where accidents are going to happen, especially as I was driving in this morning, you got to make sure that you have contingencies in place. And do the documents that you've provided naming the children as beneficiaries, what do they say if that child's not living? Does it go to the other child? Does it go to the deceased child's children? If it does go to the deceased child's children, does it go outright? Are we going to have to appoint a guardian to handle that?
Yeah,
so,
and incapacity.
Yeah.
That goes back to the guardianship issue. If, God forbid, one of your children became incapacitated and you're passed now and that money's going to go, who's going to be in charge of that money if it's left to them? And is that the way you're going to want to have it happen? Do you have grandchildren as well?
Yes.
So would you want, some thought would be, do I want their share to go down to their children, and if their children are minors, who do I want to be in charge of that if they're not around to do that, or if they're either not able or if they've passed? So these are all things that with estate planning, I know these are the type of contingencies that may or may not happen, but with estate planning we're covering all these different potential issues that life may bring your way, and we have a plan set up in place that says if this happens then this is what I want. Here's who I want in charge, here's who I want to be taking care of those things, here's maybe even instructions as to how it gets distributed as well. All right, we're going to have to take a quick break. Mary, I hope that was some help to you.
It was. Thank you.
Okay, great. All right, quick break here. When we come back, we're going to get into a little bit about IRAs and trusts again and the importance there with regard to asset protection. Join us here. We'll be right back on the Retirement Report.